Hello everyone and welcome to our webinar on GP Partnership Succession Planning. My name is Sophia Palmer. I'm an Associate Director and Solicitor at BMA Law. So just to give you a bit of background about us, we're an independent law firm established by the BMA, offering expert, cost-effective legal advice, and unlike other firms, we offer a BMA membership discount and we aim to reinvest any surpluses back into services for doctors. So just to let you know, this webinar is recorded. The webinar will be split into two sections. There will be a talk given by me on succession planning, and then a Q&A where you are free to ask any questions that you have. If you have any questions, please type these in the Q&A chat box and I will try to answer these to the best of my ability. If there are any questions that I'm unable to answer or do not have time to answer, we can follow these up after the webinar. So please do feel free to contact me. My details will be on the final slide and I will give you a few moments to jot these down at the end of the webinar. So planning for the future. Having a succession plan is key to ensuring the smooth transition of your practice following a partner retirement. It's also essential for the continuation of your NHS contract, whether that's GMS or PMS. We recommend keeping your practice in order at all times, and this means ensuring that your partnership deed is up to date and having your property arrangements in order. So what is succession planning and what does it involve? Well, it involves several things: managing the exit of outgoing partners, recruiting for new partners, or having a plan to recruit, dealing with the practice property, or potentially negotiating a practice merger or takeover. And we'll go through each of these in the next few slides. So the first step that I'm going to touch on is your partnership deed. So firstly, you need to ensure that your partnership agreement is up to date. Every time a new partner joins or leaves, we recommend taking a look at your deed and establishing whether it needs to be updated and whether the current provisions are fit for purpose. All partners should be named on your deed and it should be executed properly. And by that we mean signed and dated in the places where it should be signed and dated. You should also ensure that it accurately reflects how your property is occupied and owned, and I'll go into the property provisions in a bit more detail later on. Your partnership deed is usually the key document in managing your succession plan. So although having a partnership policy or a document in place to set out your succession plan is important, your partnership deed is really the key document that you're going to look to when dealing with incoming partners or the retirement of a partner, the buyout of a partner or the buyout of the property. You may also have a separate document called a declaration of trust. This generally tends to deal with property arrangements and it should be reviewed alongside your partnership deed if you have this. So the first step that I'm going to consider is managing the exit of a partner or partners. Your partnership agreement should specify the notice period required if a partner wishes to retire. We tend to see anywhere between 6 and 12 months in terms of a notice period. 6 months always seems to be a bit too short and doesn't really give the partnership enough time to recruit. And therefore, what I tend to see are practices are much more comfortable with at least 12 months or a clause to say a minimum of 9 months and a maximum of 12 months. The purpose of that is that you've got at least 9 months notice and a maximum of 12 months. So they can't block any other partner retirement by, say, giving 24 months notice. But all of those provisions can be reviewed within your agreement if you want us to. You may want to limit the number of partners who retire at any one time as well. To do this, you could include a clause to say that only one partner may retire in any accounting period, or a clause to say that there needs to be a gap of at least, say, 6 months before a partner hands in their notice if a partner has already served notice to retire. This just gives the partnership a bit more stability and a bit more time to recruit and plan for retirement. If you have the scenario where 2 partners hand in their notice at the same time, then you should ideally have a clause to state whose notice will be accepted. This could be the partner who's served the longest, or something as simple as the partner whose name appears first on the deed. but having those clauses within the deed are essential in case you get, say, a race to the door. We sometimes tend to see retirement ages within partnership deeds, and these may be necessary in order to succession plan, and they should always be justified on that basis. The risk of having a retirement age is that it could be deemed to be age discrimination under the Equality Act. Therefore, we recommend seeking legal advice before you use or insert that clause in your deed. And the advice is usually something along the lines of it can be justified if it's for the purposes of succession planning, therefore knowing when retirement ages are going to approach and whether a plan needs to be put in place to recruit the retiring partner. Sometimes we get asked if you can stop a partner from retiring to prevent, say, the last man standing scenario, and therefore give you time to succession plan. You can include a last man standing clause in your deed, and this usually states that where a partner falls below a certain number of partners, if a partner hands in their notice, the other partners have the option to consider whether they want to accept that notice and let the partner retire, or whether they wish to dissolve the partnership. That doesn't really help with succession planning. However, what it can do is act as a deterrent to partners racing to the door, and it can focus the intentions of the partners on recruiting new partners, succession planning, or looking for alternatives to recruitment. So, for example, a merger or a takeover. You should also consider the buyout provisions within your deed when managing the exit of a partner. The partnership deed should set out when the leaving accounts should be prepared. So whether you're going to have interim accounts to the leaving date, or whether you're going to prepare the accounts to the accounting date. So usually that's, I don't know, the 31st of March. What you would do is wait until the 31st of March to prepare that set of accounts. However, what you also need to know is after the accounts are prepared and agreed, when will that partner be paid out for their current account and capital account? And for those provisions, we always recommend seeking advice from the accountant, because they'll be able to give you the advice on when you can pay out, how much you need to pay out, and when it can be done. And if there are any disputes with regards to payout or the buyout of a share, you should have a disputes resolution clause within there. So finally, we usually get asked in terms of succession planning is, do I need a deed of retirement? The answer to that really depends on your current partnership deed and how it's drafted, and whether it includes satisfactory retirement provisions. If your deed does not include retirement provisions, or the terms of your retirement are different to those included within your partnership deed, then we would recommend putting a deed of retirement in place. Therefore, making the terms of your retirement clear for everyone to understand, or not your retirement, a partner who is retiring, so a co-partner. Remember, new partners will consider these clauses when joining, so a careful balance needs to be struck between the interests of the individual partner and the partnership. So the next point to consider when succession planning is new partners, and of course you need new partners if partners are to retire. What we've seen is it's becoming increasingly difficult to recruit new partners. So it's important that you consider the challenges faced by new partners or prospective partners. And these challenges can usually be addressed at the outset. So looking at your partnership deed to see if it's appropriate, or looking to see if there are alternative provisions that can be included. These challenges faced by new partners tend to be things such as capital buy-in. So having a capital buy-in which is too high, or it's just too much to comprehend. Premises buy-ins. Sometimes new partners don't want to buy into the premises because there's no guarantee that they'll be bought out when they leave. And there's also the added responsibility and risk of becoming a partner, and that's the personal liability that goes with partnership. It may be worth considering whether the capital buy-in is actually required. So if that's one of the hurdles, sit down with your accountant and think, how much capital do we have in the partnership, and is a new partner required to inject that capital when they join? We often see new partners join without the need to contribute to capital, or agreeing a reduced parity share to enable that new partner to build up their capital over a period of time. Again, seek advice from the accountant to ensure that any reduction in parity is appropriate, or to ensure that a capital contribution isn't required. Careful drafting should be considered, though, within the partnership deed to ensure that they are actually a partner. If they're not contributing to capital, they need to be receiving a profit share or having decision-making responsibilities, things like that. And also, consideration should be given as to whether new partners are required to buy into the property. And sometimes that's the biggest hurdle because lending needs to be taken out, or the property might not be in the best area, or it might just be a huge financial commitment that partners are scared of. So if so, and if there are going to be those provisions within the deed, it needs to set out a time frame and a share. So when the purchase needs to be made, a share, so how much they're going to own of the property, and a method for valuation. These provisions should all be agreed at the outset and should be documented within the partnership deed, so you know exactly when and how that new partner is going to contribute. Consideration should be given to a probationary period. So whether the new partner is going to be subject to a probationary period. Remember that a probationary period is for the benefit of both the new partner and the partnership. So it's not always a deterrent. It gives both parties the time to consider whether the partnership is actually the right fit. And during that probationary period, you may actually suspend the requirement to buy into capital or purchase a share of the premises. So you can say once the successful completion of the probationary period is achieved, the new partner will then buy in or start to receive a reduction in their parity share to enable them to buy in. We recommend including incoming partner provisions in your deed, even if the new partner has not joined, as it gives prospective partners the ability to see the provisions and understand what they're signing up to when they join the partnership, or if they are considering partnership. We also recommend ensuring that your leave provisions are up to date, and by that we mean your maternity, paternity, adoption and sick leave provisions. What we tend to see in older partnership agreements that haven't been updated in some time are that they're less favourable than the leave entitlements that an individual would receive if they were an employee. So that can sometimes act as a deterrent for new partners. So if you put an old partnership agreement in front of a prospective partner and they see that they're actually going to receive less maternity leave or less sick leave, then they may actually feel that partnership isn't right for them. So ensuring that those provisions are up to date and not acting as a deterrent is a good idea. We recommend tying your leave provisions into the NHS reimbursement received or any top-up locum insurance that the practice maintains, so that you're not in a sort of less favourable position. It's also worth bearing in mind that practice manager partners and nurse partners can also aid succession and help with succession planning. We can include bespoke provisions for practice manager partners or nurse partners and ensure that they've got the indemnities that they need to operate in partnership and be fully sort of protected as a partner, so they don't see it as a sort of a risky opportunity. So the other point that we mentioned at the beginning was the premises, and the premises is usually the biggest asset or the biggest liability. So careful consideration is needed when considering succession planning. If your premises is freehold, are your current partners willing to buy you out? And if so, and if that's what you want to achieve, you need to have the provisions in your partnership agreement that provide for the buyout of your share. They'll need to state when you'll be bought out, how you'll be bought out, how the premises will be valued. All of those points are key to agree at the outset, so that when you do serve your notice to retire, you can easily follow this plan that's set out within your partnership deed as to how your exit will be managed. And your exit includes the buyout of your premises share if it's a freehold property that you own a share of. If you can't sell your share of the premises, or if you don't want to, if you want to hang on to that share of the premises, then you need to consider the consequences of owning the premises as a retired partner. One of those consequences is that you may need to put a lease in place, and you may also need a property document, or say a declaration of trust between the property owners. That property document will govern how that property is owned and who's responsible for what. That's really essential, because once you leave the partnership, you will no longer be bound by the terms of the partnership deed, and therefore that separate document needs to be in place. There are consequences with this arrangement, so you'll need to consider any financial and tax implications, and also any legal costs that you're going to incur with putting these documents in place. So whether that be a lease or a property document, say a declaration of trust. So sort of full advice needs to be sought on that option. The other option that we tend to see in succession planning is sale and leaseback, and this is where the property is, say, purchased by a third party and leased back to the partnership. With this sort of arrangement, you need to consider the terms of the proposed lease carefully, to ensure that they're tenant friendly and that you're not signing up to an onerous lease that has no break clause or goes on for a sort of a lengthy period of time. The benefit of going into that sale and leaseback arrangement is that it removes the complication of selling your property if you're to retire, so selling your property to retire to continuing partners who may not actually want to buy in. If on the other hand your premises is leasehold, you need to consider whether the lease can be assigned. If not, if there's something in your agreement that doesn't allow you to assign it, or if you don't have a partner to assign, if you don't have the right sort of partner to assign it to, does your partnership agreement include the relevant indemnities? So that could be an indemnity from the continuing partners in relation to any retired partners who are stuck named on the lease. So legal advice needs to be sought, I would say, well in advance of your retirement or a partner's retirement, to ensure that firstly the partnership deed sets out how you're going to retire, but also to ensure that the terms of that deed are relevant and appropriate for the retirement. If for some reason they're not, then a deed of retirement might be the best option, or amending your current partnership agreement to bring it up to the standard it needs to be could be the other option. I've just mentioned a key point with regards to leasehold properties, and that's ensure that if your property is leasehold, you have at least discussed having something called a lease reserve fund, and a provision can be inserted within your partnership agreement to deal with this. What it essentially is it's a pot of money that the partners contribute to pay for repairs, maintenance, or dilapidations, or anything really that arises throughout the period of the lease or at the end of the lease. The reason for having that is if a partner, say, sort of is there for 10 years, but then retires just before the lease is about to come to an end, or the dilapidations arise, and they haven't contributed to the dilapidations, or a pot of money set aside for those, then there's sort of no recourse unless your partnership agreement provides for it. So I would recommend considering having some form of lease reserve fund if you don't already have one. The final point that I'm going to discuss with regards to succession planning is merging or going through a takeover. This is it's an alternative to recruiting new partners, and if you can't recruit new partners, or if that's just not the right option, then a practice merger or takeover could be the better option. What we would say is, depending on the complexity of the merger or takeover, start planning well in advance, so at least 12 months. Carry out your due diligence, so both parties should be really carrying out due diligence on each other and agreeing to sort of heads of terms, so the principles of the merger. What you need to ensure that if the merger or takeover is your part of your succession plan, then as part of your negotiations you need to discuss your exit, and this will ultimately involve drawing up a deed of retirement as part of the merger or takeover, or including specific provisions within your partnership agreement or merger documents to deal with your retirement. So all of those provisions need to be dealt with at the outset, and then included within the merger documentation. So what I'll do is I'll summarise a few of the key points that we've discussed. and then I'll be happy to take any questions. But I think the key thing is ensure that the partners in your practice share the same vision for the practice. They know the direction and they know what you're aiming for. Is it recruitment? Is it, a potential merger or takeover? With either of those options, you need to ensure that your house is in order, essentially, so that you've got all the documents that you need and that everything's in place. If you have those documents at the outset and they're fit for purpose, then you'll find that as time goes on, it's much easier. So if a partner wants to retire, you know exactly what's going to happen. Are you going to stagger the retirement? Are you going to look at your last man standing clause, or are you going to be already considering that merger or takeover? The second point is plan for your retirement and the retirement of others. So bear in mind that ultimately, there will be retirements, especially as, the partnership grows older. People will be looking to retire. So always focus on recruitment. So taking on those new partners, and making sure that what you're offering is as attractive as it can be, given the state of general practice. And as I've already said, consider merging or going through a takeover. Sometimes it can be an option. With any of these options, we would say seek financial and tax advice. So don't jump in head first. Speaking to your accountant is often, one of the most important steps, as well as speaking to a solicitor about putting the relevant documentation in place. So I hope that was useful. It's sort of a quick summary of how to go about succession planning and the things that you need to consider. I think I've just set out a few points as to why some practices prefer to use BMA law. We offer competitive rates for BMA members. These rates are discounted. We specialise in advising medical professionals. That's all we do. And we have a deep understanding of the more specific requirements in drafting that GP practices require. And we provide a variety of partnership-related services. We aim to be the one-stop shop, so we can do the partnership deed, we can deal with the deed of retirement, we can deal with the sort of merger, takeover, whatever it is that you're planning to go for. So if you would like to contact us after the webinar, my details are on the screen, and you're more than welcome to contact me individually, or you can contact our general email address and number if you would like to speak to us. So thank you very much for taking the time to listen. I can see that I've got quite a few questions, so I'm going to start working through those. If there are any questions, please do not hesitate to put these in the Q&A or the chat box. So the first question that I've got is, I do not have a partnership agreement. Do I need a deed of retirement if I'm looking to retire? So if you don't have a partnership agreement, you're essentially operating as a partnership at will. If you're a partnership at will, you can't technically retire from that partnership under the Partnership Act. So what we would say is, yes, have a sort of a robust deed of retirement that sets out how you're going to retire. You may also want to consider putting in place sort of partnership agreement provisions within that deed of retirement if you don't already have those. But a deed of retirement should set out when you're going to retire, how you're going to be paid out, what you're going to be paid out for. So that's your capital account, your current account, and if you own a share of the premises, how that premises share is going to be valued and when you're going to be paid out for that. If you're not going to be paid out for the share of the premises, you need to consider the implications of that. Look at, take advice on whether you need to put in a lease or whether you need to consider that property document to govern how you own the premises. It's essential that you take proper advice on this to ensure that you continue to receive any notional rent or rent reimbursement that you were receiving previously. My second question is, can I make the continuing partners buy me out of my share? I mean, ideally what you need for that to happen in a legal sense is a partnership deed with provisions stating how your share is valued. So your accountant will be asked to draw up leaving accounts or a set of accounts setting out what your share is worth, and then you'll be sort of paid out for that in accordance with the terms of the deed. If you don't have that, if you don't have a deed in place, then I would say yes, put that deed of retirement in place, because it will govern the exit. But also a partnership agreement is sort of even more important than that, and I would say put that in place first, because it will also deal with incoming partner provisions and so on. So third question, I think there is a difference between A, reduced parity share, and B, building up capital. A has a tendency to prevent, or B, at least prolong the period before capital parity is achieved. Perhaps what was meant was A, the limit on initial drawings, which is common confusion for reduced parity and still called a salary incorrectly by some. I mean, so a reduced parity share, you can just have a reduced parity share, which is just sort of a reduction in profit share and drawings, and you can within that clause have a provision to say that the remainder, so say you join an 80% parity, that 20% parity will be retained by the continuing partners. What you can have in sort of in contrast to that is a reduction in parity and whatever's held back. So a reduction in profit share, whatever's held back is used to build up your capital, or whatever it is you're required to contribute. I think I'm not sure what's meant by has a tendency to prevent. A has a tendency to prevent, or B has at least prolong the period before capital parity is achieved. I mean, I don't know if it would prevent, but yes, it could prolong the period. So prolong the period for capital parity, because if you're saying, well, you're going to contribute over a period of time, then yes, that there is going to be that period where you have to wait for them to build up their relevant share. So go back to the next post. How do you distinguish a merger from a takeover? So it depends on the structure. So there are sort of several models that a merger or a takeover can take. A merger is usually where two contracts are brought together and become one. That would be the most simple way of sort of describing a merger. A takeover is usually where the partners of one practice, one contract, join the partners of the other contract. So you've got two GMS contracts. The partners of GMS contract A join the partners of contract GMS contract B, and it's essentially a takeover. So one practice is taking over the assets and everything else of the other practice. And what I tend to see is practices use those terms interchangeably. So if it's a merger or takeover, they call it whatever they wish. The documentation or the legal agreements used for each for a merger or takeover are slightly different, but not incredibly different. Let me just see if there are comments in the chat here. Yeah, there are quite a few. So I'm just going to have a quick drink. Can you please discuss the last man standing clause in a bit more? So yeah, I mean, the last man standing clause, it does prevent the partnership sort of having a last partner standing. But what it does essentially, and it really depends on how it's drafted, is if you have the clause which I mentioned, where there's a provision that states if the partnership falls below, say, or falls to 4 partners, if a partner hands in their notice to retire, then that notice isn't automatically accepted. What happens is the partners have a meeting and they consider whether they wish to either accept the notice to retire, so allow that partner to retire, or say, in actual fact, we're not going to accept this notice. We are going to dissolve unless everyone votes that they're sort of happy to continue. So the result of a last man standing clause is not that it prevents the dissolution of the partnership, but in fact it could sort of bring you there quicker than you expected. But what it means is that any liabilities or losses or anything related to the dissolution of the partnership is shared amongst more partners than just one. So it will be shared amongst the 4 partners who are remaining. So just have a look. I've got a question about fees. So with fees, it really depends on what you want us to do. So if you drop us a message, send us an email, we'll be more than happy to discuss fees. Does the retiring partner have to pay capital tax on the sale of the property, and how can it be avoided? So those sort of questions are for a tax advisor or an accountant. As a lawyer, I'm not qualified to give that advice, but I would say, tax, the tax element of it really needs to be considered before sort of going down that route. I'll start from the top because I've sort of lost my way through these questions. So still not very sure about the deed of retirement. Please explain. So a deed of retirement sets out the terms on which you're going to retire from the partnership. If you've got a partnership agreement and the partnership agreement has retirement provisions within it, and you are retiring in accordance with those provisions, you most likely do not need a deed of retirement, although I'd always say seek a bit of advice. If you pick up the phone and ask us, we're more than happy to give you an answer. But if you have decided to retire on terms that are slightly different to those within the agreement, so for example, you're going to be paid out much sooner than what was previously agreed. If that's the case, then I would say put a deed of retirement in place, because that will formalise what you have agreed with the partners. Vanessa Douglas, will you be sharing the slides? Yes, of course. If the webinar is recorded, so that will be available. But if you need a copy of the slides and you just want the slides themselves, then please do drop me an email. Let's have a look. So there's a leasehold question here, which is quite specific. I would say any property questions, pop them through to me. I'll get my property colleague to pick them up. Does the retiring partner? Yeah, I've answered that one. And partial retirement. So how is the new partial retirement going to affect partnership? So by partial retirement, I'm guessing you mean reduced sessions. You can sort of have sort of a staggered retirement where you reduce your sessions, reduce your commitment to the partnership, and that in itself can sort of taper off your commitment to the partnership and enable you to put sort of other arrangements in place, or sort of force you to put other arrangements in place. So, I mean, there are sort of there are ways in which you can sort of wind down from being a partner, yet remain as a partner within the partnership. Can you put in a partnership agreement that a deed of retirement needs to be in place within X time of retirement, or is that also age discrimination? Can you put so your partnership agreement should include the retirement provisions. If you're going to put a deed of retirement in place and those provisions are different to those within the partnership agreement, I would say ensure that your deed of retirement is agreed before that partner retires. So it should be agreed, signed, dated, and the retirement date should be specified in the deed of retirement before that partner leaves. Of course, that's not required if your partnership agreement deals with it. But I would say ensure that everything is signed up to and agreed prior to the retirement date. Otherwise, you'll be doing it retrospectively, which sort of puts you in a weaker bargaining position. And is that age discrimination? So when I mentioned age discrimination earlier, that was really in relation to where you've got a retirement age. And you can have a retirement age within your deed, that's not a problem. And usually the purpose of that retirement age is to enable the practice to succession plan. So enable them to plan for upcoming retirements. So say that retirement age is, I don't know, tied in with pension age. The partners will know that, X partner will be retiring on this date. Therefore, we need to start planning for their replacement, so they'll need to start looking for a new partner to join. If you do that, I would say seek legal advice before you sort of serve notice to someone to retire under that clause, just to ensure that you're not sort of crossing over the boundary of age discrimination. So how easy is it to put a clause of last man standing, and how often is this done or exercised? I mean, it's quite simple to put a last man standing clause in. You can also, in addition to the clause, you can have several forms of last man standing clause. So you can have the one that I described. You can always also have sort of an option where you give the partners the option to buy out your share, and if they decide that they don't want to exercise that option, the result is that the partnership dissolves. That's another sort of form of last man standing, which is sort of very simple to draft into a deed, as long as your deed is sort of in good form. And how often is this done? There was a phase a few years ago where we were including last man standing clauses quite frequently. I think it's sort of less of a there seems to be less of a concern about the last man standing scenario, although it is still very much there. Sort of the narrative around that is sort of moved away slightly, but we do still include those clauses. How often are they exercised? Not very often. Most of the time, if somebody's thinking about that scenario well in advance, they would have already started their succession planning. Yeah, not very often. And as soon as you see that, and as soon as your colleagues see that in the deed, they'll think, right, we need to put a plan in place. Let's start recruiting. Let's focus on our salaried partners, and let's make the terms of our partnership deed sort of favourable, so that if you saw them, you think, well, actually, I would do better as a partner than I would as an employee. That's sort of how you want to phrase your partnership deed. And partners can have all sorts of sort of rights that employees don't have. So you can have more holiday leave if you can provide for it. Sabbatical leave we still see a lot of. So all of those things are are quite sort of nice to haves. Okay, can you send me a copy of the slides? Yes, just send me an email. My details are here. If you drop that down, send me an email, because I can't get your email addresses off Teams. If you send me an email, I'll happily share them with you. And yeah, I can't see any other questions. If I've missed anything, please do just put a question in the chat box. But I mean, I hope that was a good summary of succession planning. It sort of gives you the points to look out for. I would say start planning at the beginning. Sit down with the partners and decide on, what your plan is. Is it to take on new partners? If so, start the recruitment process as soon as you need to, but also ensure that your deed is set up for those new partners, so that you've got those new partner provisions in there. And if, in fact, the agreed process is a merger or takeover, start planning early on. So the first step would be to put the heads of terms in place to agree the intentions of each party. Those heads of terms aren't legally binding. They're just a straightforward document saying what you're all happy to agree to. And then give yourself at least 12 months, I would say, to get through the merger process, agree how the property is going to be dealt with, and agree the transfer agreement. So whether that's the business transfer agreement or merger agreement. And I think I've got one more question about NHSPS leases and partner changes. Any comments? What I would say is, I'm a corporate commercial lawyer. If you've got specific questions with regards to NHSPS leases, please do ping them through to me. I'll get my property colleague to arrange a call with you to discuss those further. But thank you very much for attending. As I've said, please do get in contact if there's anything that I can help with, and I hope you enjoyed today's session. Thank you.